Hi, this is Mo Sidor. I'm the Pro Bono Coordinator and Staff Attorney at Swords to Plowshares. And what I'll be presenting on in the next hour or so is a training for attorneys who will be staffing one of our many legal clinics here in the Bay Area. So what you're going to learn today is I'm going to start with a brief overview of Swords to Plowshares generally and the services we provide our veteran clients. Then I'm going to get into the substantive training on VA benefits, the eligibility criteria to get VA benefits. I'm going to delve into length about one in particular that we assist folks with primarily at the clinic, and that's service-connected disability compensation. And then I'm going to go over disability ratings and the claims procedure. We're going to touch briefly on the discharge upgrade process, which is the other area of law that we help veterans with at the clinic. And then I'm going to go provide a brief overview of what happens at the clinic setting. So I ask that you watch the entire training. We've condensed it. All of the information that you're going to learn today is going to be relevant to your work at the clinic. So I ask that you watch the whole thing from start to end. Thanks so much. So Swords to Plowshares was started a little over 40 years ago by returning Vietnam-era veterans who saw a need in their veteran community that was not being met by the VA or by the government. And so they were founded with this holistic approach to veteran care and primarily focusing on folks who were coming home from war, who were experiencing symptoms of PTSD, and folks who were maybe discharged from the service with less than honorable discharges. And so to that end, it was started and developed a number of different units within Swords to provide this wraparound service to veteran clients. So we have our housing unit. We have over 500 housing units in San Francisco and on Treasure Island. Last year we provided housing to 1,400 veterans, including over 100 veteran families and children. We have an Institute for Veteran Policy, IVP, which is our policy arm here at Swords that does national level policy advocacy on issues around homelessness in the veteran community and on policy work around bad paper veterans, those with less than honorable discharges. Our HSS unit has full-time social workers on staff to provide case management and support to veterans. Our employment and training unit based out of our Oakland office provides one-on-one job counseling and job readiness for veterans. And then where I work with other attorneys here at Swords and our paralegal is the legal services unit. And we do two practice areas within the legal unit. Those relating to the VA are VA benefits, VA eligibility, and then at the Department of Defense, discharge upgrades. So under the VA umbrella, we work on what are called character of discharge determinations. And this is a process for folks who have less than honorable discharges just to get them VA eligibility. And then for folks who are already VA eligible, we help with benefits claims, primarily on service-connected disability compensation claims, which is the benefit I'm going to speak about at length today, and then a few other benefits issues. And then under the Department of Defense umbrella, we help with the discharge upgrade process. So this is a process that a veteran with a less than honorable discharge can go through to request that the DoD change that discharge status on their military documents. So to begin, I'm going to give a brief overview of the VA generally. There are three branches of the VA: the Veterans Health Administration, the Veterans Benefits Administration, and then the cemeteries and memorials. The VA's Health Administration runs the country's largest integrated health care system with over 9 million patients. So they have authority over all of the VA hospitals, the major hospitals in the country, as well as the local clinics and the behavioral health clinics as well. So we run a number of our legal clinics out of these VHA facilities. Next is the Veterans Benefits Administration. They're the arm of the VA that distributes the cash benefits to veterans. So for example, the service-connected compensation benefit, GI Bill benefits to colleges and universities, home loans, and other cash benefits available to veterans. So each month, just to give you a sense of scope, the VBA dispenses over $4.5 billion in cash assistance to veterans. So they're working with quite a large budget. The smallest branch of the VA is the cemeteries and memorials, and they run the veteran cemeteries across the country. So not everybody that served in the U.S. military is actually considered a veteran at the VA. This was one of the things that I learned when I first started doing this work. Somebody could come home with 2, 3 deployments, apply for VA benefits, and literally be told that they are not a veteran. They're not going to be considered a veteran. So I'm going to start by going over who is considered a veteran and how to get folks eligibility at the VA. So kind of the first step just to get them in the door. So this is the definition, the VA's definition of who is a veteran. It's a person who has served in the active military, naval, or air service and who was discharged under conditions other than dishonorable. So I'm going to start by unpacking the first clause here. It's a bit more straightforward than the second one. So active duty. So anybody who enlisted or was an officer in a branch of the military, they're already on active duty. For the reserves or the National Guard units, in order for them to have served on active duty, their unit must have been activated. And so that often looks like their unit was activated and went on a deployment. So you need active duty. That's one of the requirements to be eligible for benefits. And then next is the service, which is federal service. So again, folks who enlisted, folks who are officers, it's already federal service or already DoD employees. Those who served in the reserves, that's actually already a federal entity, so they fit that definition or that criterion. But the National Guard is actually a state entity. The commander-in-chief of a National Guard unit is actually the governor of the state that the unit is located. So in order for someone in the Guard to have been considered to have served federal service, their unit must have been activated by the president in his capacity as commander-in-chief. So again, that often looks like their unit was deployed to Iraq or Afghanistan. So activation by a governor for a Guard unit is not sufficient. Often that looks like, perhaps responding to a natural disaster or fighting a forest fire, something to that effect. If the governor called on the unit, that's not federal service, and that wouldn't qualify. Okay, so that's the first clause. It has to be active federal service. The second clause is where we gets a little bit more complicated. So the person has to have discharged under conditions other than dishonorable. There's actually 6 different categories that you can be discharged under when you leave the service. So it's not just honorable or dishonorable. So you see them listed here on this chart. Those who were discharged with an honorable, a general under honorable conditions, or an uncharacterized discharge status. If you have one of those discharges, then your discharge is not going to preclude you from VA eligibility. So you're good to go as long as you meet the other criteria. Your discharge is not going to prevent you from being eligible. Just a bit of background, somebody who has a general under honorable conditions, that's usually someone with very minor misconduct in their service. Someone with an uncharacterized, that's usually someone who discharged during basic training, who was just not in the service long enough for the DoD to have enough information to characterize it one way or the other. And then, of course, somebody who served and received an honorable discharge. Where it gets tricky is for folks who served and were discharged with an other than honorable, or what used to be called an undesirable discharge, or those who were discharged with a bad conduct discharge as part of their punishment from a special court-martial. So a special court-martial is a misdemeanor level military court. So if the veteran is in one of those 2 categories, and they've applied for a VA benefit, this triggers what the VA calls a character of discharge determination. So I'm going to talk about that in a second. But that's what happens when anyone with what's called an OTH, or an other than honorable, or a bad conduct from a special court-martial applies for health care, service-connected compensation, a home loan, any one of those benefits, that triggers that determination process. And then just to finish up, those who served with a dishonorable, or rather received a dishonorable discharge, or received a bad conduct from a general court-martial, and that's the felony level military court. If you're in one of those 2 categories, that veteran is actually statutorily barred from VA benefits. The only way for them to get into the door at the VA is to go through the discharge upgrade process, because that process literally changes your discharge status after the fact. And so we're going to talk about that process at the end of the training. But just know that for those folks, they're not, it's usually not, those aren't a lot of the clients that we see at the clinic. But if they are in one of those categories, they have to go through the discharge upgrade process if they want VA eligibility. All right, so I'm going to go back to this yellow area, this gray area for folks with OTH or bad conduct from a special court-martial. So they've applied for a VA benefit. This triggers the character of discharge determination process at the VA. And what the VA does next is they take a look at the veteran's claims file, so their military record and any other evidence that the veteran has provided the VA. And they'd make a determination about whether the misconduct was willful and persistent, whether it involved moral turpitude, or a few other things that they look at. And so there's a great deal of advocacy that lawyers can do for veterans in this process to convince the VA that they should be allowed in and deemed honorable for VA purposes despite their discharge status. So we do a lot of work for folks at the clinics and obviously within the legal unit here at SWORDS generally for this population. So that's kind of a brief overview of this determination process, again, just to get them eligibility at the VA. Now, I'm going to talk about VA service-connected disability compensation. So let's imagine we're dealing with a veteran who's already gone through the character of discharge determination process, has been deemed honorable, or perhaps a veteran who is already eligible for VA benefits. This is a benefit that we help veterans obtain, and the purpose of it is to compensate veterans who have a disability today that diminishes their earning capacity, and that disability stems from something that happened to them in service. So the idea is that their earning capacity would be at a certain level had they not served and incurred this disability, and the VA is trying to bump them up to that level. So they provide the benefit in a monthly tax-free payment to the veteran, and the amount that the person receives is going to be based on the severity of that disability. So we're going to talk about disability ratings at the end, but it's going to be generally based on how severely the condition disables the veteran. So to prevail in a claim for service-connected compensation, the veteran client needs to prove three things to the VA. They need to prove they have a current diagnosis for the claimed condition or disability. They need to prove the in-service event or stressor, and then they need to prove nexus, meaning that the in-service event or stressor, as likely as not, caused the current disability that they live with today. So we're going to go through all three of these and figure out how does a veteran client prove each of these elements and how you can assist them at the client to develop evidence and provide this sort of information that's going to be helpful for the VA to service connect their condition and get them that monthly compensation. So the first element is current diagnosis. The veteran needs to have a current physical or mental health condition. So this is not a tort action. If the veteran was injured years ago but they have no residual effects today of that injury, that would not be something that would be compensable. So they need to have some sort of impairment today. A lot of the work that we do is help folks get service connected for post-traumatic stress disorder, or PTS or PTSD. And so, for example, in those situations, you need a current diagnosis for PTSD by a mental health professional. The VA does have a preference for their own doctors, but it is not a requirement. So a lot of folks who maybe are not eligible for VA healthcare, not enrolled in VA healthcare, they can provide private medical evidence of their diagnoses, but the VA does prefer their own doctors. So a lot of the evidence to prove this current diagnosis is obviously going to be in their current medical records. So what we can do is help them obtain copies of those medical records by filling out records request forms at the clinic. If you meet with a veteran client who perhaps is reporting symptoms, in your intake with them, but doesn't go get treatment perhaps for that condition, you might want to advise that client that they go obtain medical treatment or mental health treatment for the condition, so there's paper evidence of a medical professional, mental health professional diagnosing them with that condition. And then lastly, advising the client to provide their own statement to the VA describing what their symptoms are today and the severity of those symptoms, how they affect their daily living activities, their ability to work, their personal relationships, their mobility, things like that. Advising the client on what to include in a personal statement that they can then submit to the VA as evidence of their current symptomatology, but also evidence of how severe that current condition is, which of course would be helpful and inform what rating percentage they get. The second element is they need to prove the event in service that caused the condition. And so that's, it can be a number of things. These are very fact-specific cases, but anything from a traumatic stressor in service that causes them to have PTSD, a training accident, a car accident, a combat-related injury. They have to provide proof of the in-service event. So a lot of the evidence that we rely on to prove these events is going to be found in the veteran's military personnel and in-service medical records. So, if they were injured in service and they got treatment in service after the injury, ideally that would be documented in their service treatment records. Sometimes their military occupational specialty, their MOS, or their job, it's called something else in other branches, but basically does the job that the veteran have inform whether or not the injury took place. An example of that is somebody perhaps in the Navy who worked in a boiler room who's trying to apply for a service connection for hearing loss. The fact that there's documentation in their personnel file that shows that they worked in a boiler room is very strong evidence that they were exposed to pretty constant excessive noise that would lead to hearing loss. Again, the veteran's own personal statement about the event in service. That's always a great place to start, and advising the client in the clinic, what to include in that kind of statement, what to describe, what are the instances in service that caused them to have, the injury today. And then, of course, key in these claims is getting corroborating evidence. So if there was a car accident, perhaps, and the veteran was injured in service, getting the police report from that car accident from, the local jurisdiction where the accident took place. Getting lay statements from those who witnessed the injury, perhaps friends or family who can attest to a change in the veteran's behavior. So, for example, a veteran who, played football in high school and had no sort of physical injuries in high school, was a star athlete, but came back and has had knee problems ever since. That can help document that in service something happened to their knees. So corroborating evidence, you can get very creative, but I just encourage you in the clinic, working with these clients, to imagine you're an adjudicator at the VA and you're reviewing their file. What kind of proof would you want to see of the in-service event? And just brainstorm with the client, what kind of evidence can we look for or develop at this point to prove the event took place. Now I'm going to talk about two special evidentiary rules for both combat veterans and folks who are applying for service connection for PTSD based on military sexual assault. So we're still in element 2 here. We're still trying to prove the in-service event. But combat veterans are afforded a special lower evidentiary burden. And so if the veteran's claimed condition is the result of a combat stressor, whether it's a physical injury or a PTSD claim, the veteran's lay statement alone is sufficient to prove element 2. The reason this rule exists is because the VA recognizes that in combat, in war, there's typically not somebody on the sidelines writing down every injury, every traumatic event. You're just not going to have that kind of evidence. And so if the veteran has certain combat accolades in their military record, that is enough to afford them this lower burden. And all they need to do is write their own personal statement describing what happened to them in service that led to the physical injury or the traumatic event in the course of combat that led to them having PTSD today. So we do a lot of work with folks in drafting that lay statement, and in the clinic setting, often just giving them advice about what to include in it. And of course, they're always welcome to come back once they've written that for us to review and look over. So that's for combat veterans. That's the special rule for, again, element 2, proving the in-service event. And the other one I want to talk about is for veterans who are claiming service-connected compensation for PTSD, where the in-service trauma is a sexual assault or a rape. So I'm going to start by giving some statistics. A couple of years ago, the DoD issued their own report that 4,700 service members reported being sexually assaulted in the previous fiscal year. And afterwards, 59% of those service members perceived social retaliation and 40% perceived professional retaliation. They estimate, the DoD estimates, that only 25% of the estimated 18,900 service members reported their sexual assault or rape while on active duty. So what that says is there's going to be a lot of folks out there who experience this trauma in service, but there's not going to be a police report or any kind of documentation in service of the assault. And so with that in mind, the VA established the special evidentiary rule providing other what they call markers that the VA will look for in a veteran's service record to help corroborate the in-service assault or rape. So a couple of examples that they allow for. Obviously, if there's records from law enforcement authorities, rape crisis centers, mental health counseling centers, hospitals, physicians, a rape kit, for example, if you have that evidence, that's very strong, obviously, in corroborating that the assault took place. But if you don't have that, if the veteran requested a pregnancy or STD test, that is helpful evidence in corroborating the assault. If they submit to the VA statements from family members, roommates, fellow service members, or clergy who can either attest to what the veteran told them took place or who can attest to a change in the behavior of that veteran, that is helpful evidence in corroborating the assault. If they requested a change in military duty assignment, oftentimes the perpetrator is within their unit, and so to get away from their perpetrator, they may request an assignment change. That's helpful. And then a deterioration in their work performance or the development of a substance abuse problem. So service members are periodically given evaluations, given scores. Those scores are documented in their military personnel file. So if you can trace, the first couple of years they were getting stellar marks, and then all of a sudden there's a drop-off in their performance, and there's perhaps counseling notes in their record saying that they need to go get counseling for alcohol abuse, that would be helpful evidence in pinpointing that a traumatic event took place in service, again corroborating the veteran's account of what happened. Okay. And then the last element is nexus. And this is to prove that the event in service, as likely as not, caused the condition that they have today. So that's the standard for all factual questions actually in these claims. And it basically means that the veteran needs to show that there's at least a 50-50 chance that they have PTSD today, they have knee problems today, they have hearing loss, whatever the claimed condition is, as a result of the event you've proven in element 2. So there's a couple different theories of nexus that I want to go over that you may encounter with clients at the clinic. Direct nexus is the one I've sort of been referencing, and it's just that the condition they have today is the condition that began in service. Secondary service connection is when you have a situation where another condition has resulted from the veteran having lived with the service-connected condition. So an example of that is, you have a left knee condition that is service-connected. As a result, you've spent the last decade favoring your right leg, which has developed a strain in your right hip. Well, you can get service-connected disability compensation for your right hip so long as you prove that it's as likely as not related to your left knee issue. And then aggravation is another one we commonly see, and that's where a veteran enters the service with a pre-existing condition. The condition is not so severe that it prevents them from enlisting, but something happens to them in service that aggravates that condition. The fact that it existed before does not automatically prevent the person from being able to get compensation for the condition today. All you need to prove in those claims is that the condition worsened above and beyond the natural course the condition would have taken. So that usually means pinpointing some event that took place in service that aggravated the condition. So how do you prove nexus? Ideally, you have your doctor, your treating doctor, or mental health professional write a letter to include in your claim that says it's in their opinion, as likely as not the condition is the result of what happened in service. Or perhaps there's evidence in their medical record that links their condition to what happened in service. So, for example, every time they went to go get mental health treatment for PTSD, they're talking about the in-service sexual assault. That clearly shows a connection between the assault and their PTSD diagnosis today. So in the clinic setting, you know, we talk to them about how to prove this, give them that advice and guidance to go talk to their doctor, see if the doctor is amenable to writing some kind of letter. And we can also request their medical records, you know, which is helpful to prove the first element, that they currently have a diagnosis, and also to prove nexus if we can see in those medical records a link between the event in service, some discussion of the event in service, and their treatment today. So just a quick overview before I move on. The 3 elements of service connection: you got to prove the current diagnosis for the claimed condition. You have to prove the in-service event, so either that they were initially diagnosed with the condition in service, you have to prove the injury took place in service, or for PTSD claims you have to prove the traumatic event took place. And then you need to prove nexus, which is that it's as likely as not the condition they have is related to their military service in that event in element 2. Okay, so once the veteran has compiled their evidence, written their personal statement, gathered their medical evidence, provided excerpts of their military record that help prove these 3 elements, they submit that to the VA. And if the VA sees enough in there, in that application, that there's probably a claim here, they will schedule that veteran with a one-time compensation and pension evaluation. Now, this is a one-time evaluation. The purpose of it is not to treat the veteran for the claimed condition, and the doctor conducting the exam is not going to be somebody that the veteran is familiar with. The sole purpose is for a doctor to take a look at the veteran and offer their opinion about whether or not the veteran has that current diagnosis for that condition, the severity of the veteran's symptoms, and they offer their opinion about nexus. So it's a really important exam. We do a lot of work in the clinic preparing veterans for that exam once they've been scheduled. But the rating percentage that they receive for that claimed condition, if they prevail in their claim, is going to be based in large part on the results of that compensation and pension evaluation and all the medical evidence that the VA sees about the current severity of their symptoms that they have in their claims file. And so you'll see here on the screen, these are the different monthly compensations that correspond with a different rating percentage. So they go up in 10% increments, and it ranges from anywhere, from $133 up to $2,900. And this is the rate that a single veteran is paid. So there's additional compensation if they have dependents, if they have a spouse or children, and then there's some supplemental benefits that we also assist veterans with, but this is sort of the base pay, so you have an idea of how much folks are getting based on the severity of their disability. Now I'm going to provide a brief overview of claims procedure, but I just want to preface this by saying you don't have to memorize this. You know, we're gonna prepare you before you meet with the client and go over where the claim is procedurally for that veteran before you meet with them. But I wanted to give everyone a sense of the life of a claim. So the first step is typically to file an intent to file form. So this is a one-page form. We fill them out frequently at the clinic and get those filed for folks. And this is essentially a placeholder. If the veteran is successful in their claim eventually, they will get back pay to the date that we filed this intent to file form. So it's important that it gets in right away. Their next step is to gather supportive evidence, obtain the medical treatment to get that current diagnosis, write their personal statement describing, you know, their current symptoms, what happened to them in service, and any other corroborating evidence or helpful evidence for their claim. And we provide a lot of guidance to clinic clients about those next steps and what they need to look for, what they need to gather. The next step is to file the formal application for service-connected disability. So they're going to need to file that application. It's a 4-page VA form within 1 year of filing the intent to file form. So they can certainly file it sooner than that, but they have at max 1 year to gather that information and file that application. And they want to submit all their supporting evidence with the application at one time to the VA. So like I said, if there's enough information there that looks like there's a claim, the VA will then schedule them with a compensation and pension exam, a C&P exam that they'll need to attend, and usually within weeks or maybe a few months after that exam, the VA will then issue their decision letter. And that decision letter will go into whether or not the VA has deemed the condition service-connected or not. If they haven't, why, what evidence was missing. And if they did service-connect the condition, they'll have on there what rating percentage the veteran received. So if the veteran disagrees with anything in that decision, either whether or not something was service-connected, deemed service-connected, or maybe the rating percentage that they were awarded for a given condition, if they disagree with it, they can file an appeal if it's within 1 year. So 1 year of the VA decision letter, they can file a notice of disagreement. If it's been more than 1 year, which is sometimes the case, you have folks at the clinic who maybe applied 10 years ago, got denied and didn't work on it, and now they want to work on it again. They certainly can, but the VA is not going to continue to look at the same materials over and over again and deny the claim. So the VA will only look at a claim again and reopen it if the veteran files new and material evidence. So that's something they didn't look at the first time and something that speaks to the reason the claim was denied. So of course we'd want to get some information about why the claim was denied to best advise them on what kind of evidence to provide today. So anyway, that's kind of a brief overview, but like I mentioned, we'll have some more detailed information about what where the veteran's claim is procedurally once you meet with them at the clinic. All right, so I'm going to go over a quick example client to give you an idea of a hypothetical consultation that you may have with a veteran in the clinic setting. So let's meet John Smith. He's a Vietnam-era Navy veteran, and he's seeking advice today about a service-connected compensation claim for PTSD based on military sexual trauma. So in your intake interview with John, he describes that he experiences flashbacks, nightmares, difficulty sleeping, and he fears leaving his home. Some pretty standard symptoms of PTSD. And he was in counseling 6 years ago at the VA in Palo Alto, but he doesn't get any mental health treatment today. So what kind of advice, how are you going to help John prove element number 1 for his claim? So some ideas are advising him to maybe go get treatment today. If he got treatment 6 years ago and got a diagnosis maybe back then, he should start again, get more current medical evidence of his current symptomatology and his current diagnosis. Other advice would be to request and review those Palo Alto VA records, so we can do that in the clinic and see perhaps was he diagnosed with PTSD back then. Is there any helpful nexus evidence perhaps where he's discussing the in-service trauma in the course of his treatment? And then lastly, having him write his own personal statement, which would be very helpful for the VA to see his own, or to hear rather, his own experience with the flashbacks, the nightmares, the other symptoms that he's currently having. Okay, so next, he describes to you that shortly after the rape, he recalls requesting an STD test, and he told his sister about what happened. So in the clinic setting, hearing that, I would want to request his military records and his in-service medical records. Because hopefully there's documentation in there of this STD test request and hopefully results. And so we can do that at the clinic. It's a simple one-page form that we can fill out with the veteran and request that those records get sent to his address. And of course, if he needs assistance reviewing them at a later date, he's always welcome to come back, and we do records reviews for clinic clients all the time. So that's another service we provide. Another advice to him would be to reach out to his sister, see what she remembers, and hopefully she's open to writing a statement that he can include as part of his claim, describing what she knows about the event in service. The event in service. And then lastly, his own personal statement should include his account of what took place. So all the other stuff is going to help corroborate his own statement about what happened. All right, now I'm going to briefly touch on discharge upgrades, which is the other area of law that we assist veterans with in the client. We primarily do VA benefits work, but every once in a while we get a discharge upgrade client, and so I wanted to go over this briefly with you. But of course, if we do get a client who is seeking a discharge upgrade, we're going to give you a lot more information before you meet with that client about that person's specific case. But by overview, it is a process through the Department of Defense. So we're not at the VA at all right now. It's a DOD process, and it changes, if successful, it will change the veteran's discharge status on their military separation document, which is called a DD-214. And so just by contrast, the VA's character of discharge determination process that I spoke about at the beginning, that allows folks with other than honorable or bad conduct discharges, it affords them VA eligibility. That process does not change their discharge status. If you want to literally change what your discharge is on your DD-214, discharge upgrade is the only way to do that. And so what is the DOD, what are the boards that the DOD look for? A couple of things. Mitigation for the misconduct that led to the discharge status. So if there's any sort of explanation, for example, if they went AWOL to go home to take care of an ailing parent and there was nobody else available to do that, that certainly would be mitigation. They also look for whether there's a causal link between the misconduct and PTSD symptoms. So, for example, if a veteran came home their second deployment and they smoked marijuana to help alleviate their anxiety and their PTSD symptoms that at that time were going untreated and undiagnosed, and they get kicked out with an other than honorable for that one-time marijuana use, if the board sees in the evidence that the veteran includes in their application a causal link between that one-time drug use and PTSD, they will offer liberal consideration to that veteran's application. So we do a lot of work for folks who fit that fact pattern. So mitigation for the misconduct, any accomplishments in service. So obviously the sacrifice of deploying, folks who served in combat, any promotions, early promotions, basically any great things that they accomplished while they were in the military. And then lastly, they look at what the veteran has been doing since separation. So any volunteer work, community involvement, volunteering at their church, working with children, things like that, if they've held a steady job. If the misconduct was substance abuse related or alcohol abuse related, proof perhaps that they've been successful at a sobriety program, that would be helpful. So all the good stuff they've been doing since they got out of the military. And the application, it's a packet that the veteran would put together, and we have a very detailed, actually, self-help material on this that we often send clients away with that includes a lot of this information in more detail. So that's available for them at the clinic, and we give that out. But for your own information, the packet includes the one-page application, DOD application for a discharge upgrade. It'll want to include the veteran's personal statement that sort of speaks to these three things that the board looks for. Any corroborating evidence to help prove the mitigation, corroboration, perhaps in their service record that helps show all their accomplishments in service. And then character reference letters, so folks who can speak to, the veteran today and his great character, or folks that he served with who can speak to all the great things that he did in service and what he contributed to their unit, for example. So all of those materials would get sent to the DOD for their review. All right, so I'm going to go over a quick rundown of the steps we take with a clinic client. So there's an initial intake that we have already done with the client, and we've obtained their identifying information, some demographic information, military service information, and a brief idea of what the issue is that they came in today. So if it's service-connected compensation, what the conditions are for, where the claim is procedurally, if it's discharge upgrade, what was their discharge, when did they separate, things like that. So we've already obtained a lot of information about the client before you'll meet with them in the clinic. And then before your client meeting, and we'll have you paired up, 2 attorneys, or 2 to 3 attorneys, usually meeting with one client at a time, we'll sit down with you, an attorney from SWORDS will sit down with you and go over what we know already about the client, fill in some information, we'll give you some guidance about what you'll want to accomplish in the intake interview, what kind of information you'll want to gather, and then we'll give you some blank forms that we think you may or may not need to fill out. So if we know it's an initial claim, we'll give you some intent to file forms. If it's an appeal and we know it's within 1 year, we might give you a notice of disagreement form. So there's no need to memorize what forms are for what. We'll provide you the kind of paperwork that you'll likely need to fill out with the client. And then we'll bring the client in, and you'll meet with the client. I'll go over in a second kind of what happens in that client meeting. But just to know that during that time when you are meeting with the client, there is going to be at least one swords attorney at the clinic whose sole job is to provide ongoing guidance and assistance to the attorneys meeting with folks that day. And so do not hesitate to come on out, grab one of us, and ask us any questions. You know, you're going to meet with clients, maybe some information is going to come forward that's game-changing. You need some guidance on next steps. Maybe the veteran is going to ask you questions you need help answering. That's what we're here for. So do not hesitate to come on out and ask us for any guidance. We're here to help. And then right before the client leaves, when it looks like things are almost finished, you're going to come out and grab one of us, and we are going to do a final check before the client leaves. And the reason for that is, a lot of the folks who we serve at the clinic are low income or homeless. They may not have consistent contact information. This may be the only time that we ever meet with them. So we want to make sure all the T's are crossed and I's are dotted, and all the questions that we've asked have been answered. So that's one final check-in with us before the client leaves. And then once the client is gone, we're going to have a quick debrief, answer any questions. You can give us some feedback on that before the next client. So what happens in the client meeting? So your job, first and foremost, is really to fact gather and get some information from the clinic client about their claim, about their situation. So if it's a service connection claim, it's usually getting up front a list of the conditions that they're trying to get service connected for, and going element by element to try to find, do they have a current diagnosis? What is the event that happened in service, and have we, do we have good evidence to prove it? What, if any, nexus issues may arise? And then, if it's a discharge upgrade, talking to them about what happened around their discharge, if there was any mitigation, see what they've been doing with their life since they got out, all the sort of relevant information you'd want to know to sort of assess the claim. And then we often, are providing information to veterans about these processes. So I hear a lot of times from veterans, they have a knee problem. It developed in the service. Here's what happened. I've had that knee problem ever since. I filed my claim. It got denied. I don't know why. Because, to them, it's clear, right? This is a service-related injury. But, of course, the VA has these three elements, and they need evidence for all three. And so helping the veteran understand, like, look, these are the three things the VA needs to see. And although, everything you're saying is true, we need evidence to prove all three. So let's meet right now. Let's go over this and figure out what additional evidence we can be providing the VA now to sort of prove each element, and explaining to them what those elements are. So just, using it as an opportunity to educate the veteran on this claims process. And similarly, of course, to the discharge upgrade, what the board is going to be looking for, what they'll need to include in their application, information like that, so they walk away with, a solid sense of what they need to do to be successful in these claims, in these processes. We do a lot of records requests. So as hopefully you've seen from the training today, a lot of the evidence that you need to prove the three elements of service connection are going to be found in the veteran's personnel file, their service treatment records, and their current VA medical records. And so we can request copies of those. I just ask that when you fill out forms for a veteran, that you guys fill the forms out. Just make sure that the veteran signs them at the end. Okay, and then advising them on evidence development. This is huge. So what they'll need to include in their personal statement, about what happened in service, about their symptoms today, drafting for them a list of folks they need to go and contact about getting corroborating letters, or maybe character reference letters if it's discharge upgrade, advising them on getting medical treatment so that there's a paper trail of their current diagnosis, or a nexus letter from their doctor. So obviously, it's, these claims are very fact-specific. What you'll be advising is going to depend on what the veteran has told you. But of course, like I mentioned, we're here to provide you guidance and assistance as you learn more from the veteran about what's going on with their claim or their case. And then lastly, filling out VA claims paperwork to kind of move the ball forward, get some some movement on their claim. So that's, if it's an initial claim, that intent to file form, requesting a ratings increase. Perhaps somebody's already service connected, but they want to increase their rating because that condition has worsened. Or maybe filing appeals forms with the VA to preserve their appeal rights. So like I said, we usually are the ones filling out the paperwork, but always make sure that the veteran signs everything before they leave. Okay, so hopefully that was a helpful review of what goes on at the clinic and service-connected compensation and discharge upgrade. Please know that I am available to answer any and all questions about information on this training, about the clinics generally. So you can reach me at this email address or that phone number there on the screen. Again, my name is Mo Sidor. Thank you so much for your time today.